still have a few questions as I was going through this myself.
Sure.
And because I always think that it's the answer is in the rules, and then it's not, right? So the first question is when you okay, let's say I want to fill out a request to admit to the other side. So I fill it out and I serve it to the other side. Now, do I have to file a copy at the courthouse as well?
That's a really good question. And the answer is no. You
Oh,
just have
okay.
to serve it.
You just have to serve it. Okay.
That's right.
And same with the response. Like they respond to me. I don't have to file anything for the
That's
request.
correct.
Oh, okay.
You would only be filing it for the purposes of relying on it.
Oh, okay.
Okay. If there is no if there's no response, okay.
If there's
Right.
no,
Like in other words, if you want deemed admissions,
yeah,
then you're going to be filing your request to admit with an affidavit of service showing that you served it on, January 1st, and then telling the court there was no response by January 20th
right.
or 21st. And so that would be one reason you'd be filing it. There's a second reason to file it,
Uh-huh.
and that is at the end when we get to costs, which we didn't really discuss, right? So let's just quickly discuss that. If you deny a fact, right,
Yeah.
that the court makes a finding about,
Right.
and it's an important fact,
Right.
okay? Many times you'll read a court case and the court says, there were lots of issues, but we really spent like 3 days on this one issue,
Right.
right? So you can say to the court, I asked them if they agreed to this fact and they
Right.
denied it.
Mm-hmm.
We went to trial or motion, like
Mm-hmm.
whatever part of the case, and the court made a determination of that was the fact.
Right.
And had they admitted it, we wouldn't have had 3 days of court. So I want costs to represent that waste of time.
Yeah,
That would be a reason to take it seriously of admitting and denying. Now, most cases don't go that far,
right.
in realistically, but that would be the discouragement of blanket denying without any thought. That technically, if you're going to be fighting over a fact and you lose on that fact, right, then there could be a cost consequence.
If you refuse to admit in your response, you're supposed to give a reason. What if you don't? Suppose you don't give a reason.
Right. So for refusal, right?
Yeah.
Not for denial.
Yeah.
Technically, you haven't responded to the.
Oh, I see.
So I would say that possibly is a deemed admission.
I see.
Okay, I think that would be the risk.
Right.
What I would, if depending on the context of how many other questions, I personally would send a follow-up and say you missed that box.
Oh, okay. Well,
right?
that's very fair.
Because technically technically you could bring a motion. People don't do this, but technically you could bring a motion to have that fact determined.
Right? Yes. Okay, so let's say you do want to refuse to admit, and you do want to give a reason. Now, should you be attaching evidence in that response?
That's a really good question. Usually the responses for refusals are very short, just like I said. I just gave, irrelevant, argumentative, or
Oh,
whatever.
right, yeah,
right. So I think you're giving the legal basis for refusing rather than the factual basis for refusing. Okay. I want to add to that, since we're talking about refusals, that list that I had can apply certainly for documents also.
Oh, right. Yeah, that makes
So
sense.
if there is a document that looks like it's notes between a lawyer and a client, you would say, maybe it is legitimate, maybe it's not, maybe it's genuine, maybe it's not, but I'm refusing because it's legal, it's privilege.
Okay, next question. Once you have, okay, let's say you've gone through the request to admit and you received a response, right? And then we went through it just now. So let's say now we come to trial, right? And I think you mentioned that you do include them in the trial record. I forget. Do you include or how?
So if there are, again, so if there are items that are facts that are admitted to, then that can go into an agreed statement of fact
Right. That goes
document.
into the agreed statement of
Okay.
facts, right?
And it doesn't even have to be signed by both parties in a sense, because it came from the process of Form 22 and 22A,
Interesting.
right?
Okay. Right.
I would probably note that in the agreed
Interesting.
facts.
Hmm.
The following facts were admitted by request to, response to request to admit Form 22A dated blank. And you
Ah.
list those facts.
Okay.
And then there could be another list of facts that were agreed to in addition to that between the parties. Okay. Um, if something is not agreed, so that's not, if something is not agreed to, then you don't include anything. You just go to trial.
Oh,
Right?
right,
And,
right, right.
and
Yeah.
then you have to go. And then there's the issue of people who do not respond to the request to admit, and you
Right.
include that with your affidavit of service to show these are the facts I asked them to admit. They did not respond. I want deemed
Oh.
admissions.
And this is called because the first document is called agreed statement of facts. The one that you're listing all the ones that they ignored. What's that title of the document
There,
called?
there is no,
Oh, there's
you
no,
just include the
you just
actual Form 22
oh, got it. You just include the
with
okay
your affidavit, with a Form 6B affidavit of
as a
service,
service.
prove that you
I
provided it,
did
right?
okay. Okay.
And then there's further evidence, doesn't have to be in an affidavit, perhaps it could be, where you say, there, I did not receive a response to this request to admit.
Okay.
Okay.
Right. Next question, I just want to emphasize it because I think this must come up often, missing the deadline. I think you did cover it just now, but I just wanted to repeat again. So if you were served a request to admit and you missed the deadline, so okay, let me see if I remember now.
No, so it's a really good question. Like, what happens on day 21?
Yeah, because right
Right.
away, like,
So let me tell you what can happen on day 21. Two things can happen. Okay. I told you there's a lot of case law about in the breach of people who don't do it.
yeah.
Much of that case law is not from a trial. It's from what we call a Rule 16 motion for summary judgment,
Oh,
where you say, I asked them to admit or deny, they didn't respond, so they admitted, therefore, there's really no reason to go to trial because we have
right,
all the facts.
right,
Let's have a summary trial in a sense, that's why it's called summary judgment,
right,
and get it over with.
right.
It happens. That happens a lot. That's why there's so much case law on it.
Hmm.
Okay, it was actually we're talking now in July of 2024. There was a Court of Appeal case that just happened, exactly that scenario, and the Court of Appeal said, "Got to take these things seriously."
Whoa,
Yeah. Okay. So that's option number one, where you go to a summary judgment because the facts have
right,
been okay.
right.
Then you go on to the other end where the case continues, people don't really act on it,
Yeah,
okay? And then you get to trial, and then suddenly they hold it up.
right.
And there's a motion now to set aside the admissions,
Oh, my.
okay? It's usually those two extremes. People don't usually do it in the middle, because if you're going to be sensible about it, there's going to be a letter that says, I'm not responding to it within the 20 days, please consent, or can we agree that we'll do it after X event? Something, there's going to be some conversation about it. You're not going to just let it sit. Okay, so the middle is not so common. It's the two extremes of going straight to a trial through summary judgment or getting to trial, like just the matter dragging along until it gets to trial, and then somebody holds it up and says, you never responded to it. And then the other side's like, oh my God, I gotta bring a motion to set aside the admissions. And we went through the test.
When I was a student, one of my mentors said, what was it? Oh, the default judgment one. Well, Heather, you think that just because the other side doesn't respond to that, the default judgment, you're going to be, winning for sure. Well, not necessarily, because the judge is going to say, well, did you remind them? Did you remind them? Did you remind them? So that my mentor said to me that I'm supposed to remind them like at least 3 times before I bring the motion for default judgment. So now, analogously here, if you send a request to admit and the other side has no response, isn't it more like almost like courteous to remind them, hey, I sent you a request a request to admit, and it's been 20 days, there's no response. Just a courteous, a friendly reminder that
I
I'll
gotta
give you
tell,
like something like that.
it's a good question. That's actually a good analogy. I really like, I appreciate that.
Yeah.
Um, it really depends on the I want to say it depends on circumstances, but I actually want to tell you that the case law kind of leans on the stricter side. If you can
Wow.
prove that you served it and the other party just let it go, that's on them.
That's amazing.
Not on you to follow up.
Wow, that's amazing. That's really powerful. It's a very
Yeah,
powerful
it is
tool.
very powerful. Again, it's very powerful. It's a lot of work to put together. It's definitely a lot of work to respond to. It's usually a hassle when there's lots, like, if it's used properly, if you can come up with 25 facts, 25, not 105, right?
Yeah.
Just 25 facts. That could be a very powerful use of your time to narrow issues of fact, especially in cases that are
Amazing.
factually heavy,
So
right?
so it sounds like from today's session, the best time, like you said, is probably shortly after the discovery stage. And but while things are still fresh in your mind, right? Would you say that that might be?
It's a really, this is a really excellent, if there was like the hardest question is, what is the best time to serve this
Yeah,
document, right?
yeah,
But in practicality,
okay,
most people only serve it after the trial management conference, between the trial management conference and the trial. And the reason why they do at that stage is because they see it's going to trial, so they're going to
yeah,
throw anything to avoid it.
right,
But more reactively, there's a question in our trial management endorsement form, the TSEP form, the trial scheduling form, for have the parties served request to admit, and here what's the timeline. So
oh,
that question is actually put in at the trial management phase, and so it wakes people up.
wow, it triggers
Yeah,
their
it's a
a request to
trigger.
admit.
Yeah, and it's almost like too little, too late, right? Because they're
Yeah,
already barreling on to trial, that such an admission is actually going to be helpful, other than maybe to narrow the trial, but not to prevent the trial. So I think in the best of all worlds, which is not common, is that between the case conference and the settlement conference,
right,
if we did things correctly,
yeah,
and there was questioning, just like let's just say this was a very high conflict case, and there was questioning right
right.
at the tip of the end of questioning to the settlement conference. That would be the place that you can have a very meaningful settlement conference. Except it's usually very, because the way scheduling is for questioning, it's never what people expect. That's a very tight moment of time, so it's not likely
Well,
it's
I'm glad you mentioned this because this is something to sort of like think about, just something to work with, right?
it's 100% something to think about, which is
Yeah,
what facts are you fighting? People like to think about what law they're fighting for, like the other
yeah,
side wants spousal support. I don't want to pay spousal support, something like
yes.
that. Law, but what facts are we fighting over? It is fascinating because the two interplay. You can't have one without the other.
And it's amazing how much case law is generated, right? From
Yeah, especially from not responding to a piece of paper.
but the thing, I mean, I know that this happened many times when I was studying civil litigation, is that the court, I guess the rules committee, they come up with all these mechanisms to try to make the process easier, more streamlined, more time efficient. And then somehow the rule just gets used or abused. Um, for another purpose, I find.
If I were to conclude,
Mm,
this is a very specific tool in a
yes.
toolbox that is very easy. A hammer works really well on nails, but it can also break walls, right? If you miss. And so it's very easy to abuse a request to admit in the wrong hands. It very often is abused, but that shouldn't take away from the fact that it can also be a very powerful tool to legitimately try to narrow what's in dispute.
So thank you, Shmuel, for sharing this amazing bit of information with us again, and hopefully it will help a lot of people in terms of saving time and money, and also reassure a lot of people what it's about. Because I think when you're served a request to admit, you're like, "What is this?" and can I just ignore it? That's probably the first two questions that come to your head. And thanks everyone for watching. If you're new to our channel, don't forget to hit the subscribe button and also like and share if you like this video. And we're going to see you the next time. Bye.